In order to understand what a preference is, it helps further to know the two big goals in bankruptcy law. The first goal has a laudable pedigree. It goes back to the Code of Hammurabi in the First Babylonian Empire, to the Bible, to ancient Roman law, to the U.S. Constitution, and that is to give the debtor a fresh financial start. The other side of the equation, of course, is the creditors. And that leads to the second big goal of bankruptcy law, and that's to make sure that all similarly situated creditors are treated equally and fairly. Now, there are a couple of ways that debtors will violate that second big goal of treating all similarly situated creditors the same. Number one, they won't list all their creditors in their bankruptcy petition. That's a big no-no. That is an imprisonable offense because it constitutes perjury, since you will be swearing under penalty of perjury that, among other things, you've listed all of your creditors. So you want to make sure you list all your creditors. The second way in which debtors will violate this big goal of treating similarly situated creditors the same is in anticipation of bankruptcy, they'll make preferential payments to a given creditor. Maybe they're hoping to curry favor with a creditor, or the creditor's a family member, a close business associate. You might think, well, wait a minute, I'm going to take care of my brother, aren't I? Well, when you give your brother that payment to pay the antecedent debt, what are you doing? You're treating your brother better than other similarly situated creditors. So you're violating that big goal of making sure that all similarly situated creditors are treated the same. When you do that, in bankruptcy, this is, of course, you did this before you filed the bankruptcy. Once the bankruptcy is filed, then whoever is the responsible party, either a trustee or if it's you as the debtor in possession in a Chapter 11, will file a lawsuit, an adversary proceeding, to recover that preference. Now, of course, there's a practical matter, and that is, let's say the preference was $500. You owed your brother $500, and you paid him a couple of weeks before filing the bankruptcy papers. Nobody's going to try to avoid that preference because just the cost of filing the adversary proceeding alone is going to far exceed $500. So where the cutoff is going to depend on who the responsible party is, whether the trustee or the debtor in possession. But somewhere along the line, there's a sweet spot, at which point, let's just, for definiteness, say the trustee is going to initiate that adversary proceeding to undo the preference and seize the money and not return it to you, but to use it to pay all the creditors on a pro rata basis according to certain priority rules that are listed in the bankruptcy code. So a preference lawsuit is a lawsuit to undo or to avoid the preference. And this is a somewhat unusual usage of the word avoid. It means to render null and void.